important example. But the other important example is PPU. There has been an issue with PPU in Burundi. PPU, my lord, I think now will be the equivalent of special forces. And this is what Justice Odoki had to say. That, my lord, would be on page, the last part of the resolution of issue number 4. The PPU exceeded their powers by engaging in the intimidation and harassment of petitioners, agents, and supporters. The question then is whether the first respondent is responsible for their action. There was no evidence adduced to prove that the first respondent knew, one, and consented to those actions, or approved them. It may be said that, as the head of state, who is guarded by the PPU, he ought to have known what the PPU was doing in Rukungi. That may be a good moral judgment or expectation, but it is not evidence or tact. The first respondent was also a candidate who was busy campaigning throughout the country. There was no evidence that he was responsible for the deployment of the PPU. Therefore, it cannot be assumed that he knew or consented to their actions. The petitioner failed to discharge the burden of proof to their satisfaction of court. My lord, I can go on and on. That's the judgment of Justice Odoki. When we go to the judgment of Justice Karokora, this is what he had to say in respect of proving illegal. No, different point, my lord. On the effect on the proof of illegal practices. That illegal practices, this is page 865. At least I have highlighted this part where I can just mark it for you. You can bear with. This issue, it was also canvassed by that Justice Odoki, but this is what he said that, however, it is always important to avoid elevating suspicion and expectation to the status of proof. You know, this is in respect of illegal practices and electoral offenses. The question that the court is giving to whoever is prosecuting an election petition is that, please, you should have a demarcated boundary between suspicion and speculation, and do not mistake the same as proof. I know that's just but also you must prove that there is connection of the so-called agents to the respondent, and in this case it would be the first. My lord, the same is true for Justice Mulenga. I have highlighted those parts. And when it goes to non-compliance, I am most interested in the decision of Justice Karokora. On the issue of non-compliance, and my lord, that hints to what my senior colleague was talking about, these tests and why they are setting the standard. My lord, I will read one of the excerpts to hint to that. In my opinion, there is no way we can avoid considering the numbers of voters, of votes a candidate got over the other. If the numbers of votes were used in determining the winner of the election, how can we hear the election petition challenging the winner that he unfairly won the election without considering numbers. And for instance, if the first respondent obtained 5,123,360 votes, while the petitioner got 2,559,95 votes, how can we hold that the first respondent was not validly elected without considering numbers of votes which he, the first respondent, obtained over the petition? My Lord, I can go on and on. But this goes to show you the point that we have been making. Elections are about numbers. The others are really second. Elections are about numbers. And there is no way a court would sit to determine who actually won without considering numbers. That's what the decision said. Now, my Lord, why are we highlighting this decision? Is that there is a tirade of decisions from High Court, Court of Appeal. All of them seem to be going against the Supreme Court. And my Lord, the rider is really Article 132, 34, clause 2, 32, clause 4, on the doctrine precedence. If it is respected, we would not have a problem. This petition will not be here. And that's why I'm saying, if it is read, they can withdraw it. Now, my Lord, that takes me to where I started. Where I started was, if the Court of Appeal has made a decision, there is no reason why another Court of Appeal, different band, 3, would sit and set aside a decision made by them. That is wrong, and that decision becomes by jury. And you have many of them in volume 1, 2, 3, 4. That is the decision my senior colleague, Mr. Mbabazi, highlighted, the wonderful time. But my Lord, I will take you to the decision of Akelo.
Acheng Saro Eli. Should be on.
My Lord, it is on page 679 of volume 2. Volume 2. My Lord, the petitioner highlighted what I think they consider as the relevant part. But I will show you, my Lord, that if they had read this decision with the spirit with which we read it, this petition could not be here. Because it is on all four. One, this petition, my Lord, the results that were not considered were of 17 polling stations. Yes, my Lord. Yes, my Lord. Yes. Of no constitutional Supreme Court. Because, my Lord, why we are saying. Yes, my Lord.
I was waiting for you to point them out.
My Lord,
they were in fact,
in other words, my Lord, what I'm
and they wanted you to tell me what are those and where are they, from which decisions are they departed.
Yes, my Lord, you have Apollo Kantinti, you have Hapenning. Okay. Yes, but my Lord, what I'm doing, I'm just giving a sample.
You made that point.
Yes, my Lord.
So now you illustrate. So I can make sense of that.
My Lord, with your permission, I wish to first sample those two, but perhaps I can highlight them and give it to court. That is Kantinti, Apollo Kantinti. My Lord, it had already been cited. So. And then Hapenning, which my colleague really highlighted what a problem was. Now, my Lord, let me go to the decision of Acheng Saro. Yes, my Lord. My Lord, the decision I read, especially the last one of Nalukoola, said Elections are about numbers. About numbers. One. No, before I go there, my lord, now that you have brought it.
Okay.
No, well, what I'm saying, the holding of the Supreme Court, my lord, it is going to be juxtaposed against the holdings of all these other decisions that we think are per incuriam. What we are saying, my lord, the point is because, my lord, unless you can allow me and I go the holding, but we will enter into the next day.
No, Mr. Wage, you just give it.
Yes, my lord, by way of sampling, my lord. What I had said, my lord, I started from the point one, is that the precedent, the doctrine of precedent is cardinal in our jurisprudence.
That's okay, I admitted that.
Yes, my lord. My lord, and I started with the Supreme Court decision, and I highlighted issues that were settled that are also in issue in this matter. The issue of hearsay, the issue of proving electoral offences. For continuity, my lord, I am saying, the decision of Karokora, I could have gone on and on, my lord, but I have highlighted the important parts, is that elections are about numbers. And this goes on to the decision of Odoki, this goes on to also the decision of Justice Mulenga, that elections are about numbers. Now, when you come to an election petition, and the argument is that you cannot use numbers against the argument of disenfranchisement, you are departing from the decision of the Supreme Court. That's not my lord, that's my lord. And with your permission, I can now go to highlight what I am most interested in. Because, my lord, I hope that I would not go because it would be done in assessment of evidence. For example, in Kantinch, I think 9 polling stations were in East, were not tallied, to be exact. And then that was the basis of overturning the election. In Wakaima, I think a similar scenario, 24 polling stations. And the registered voters were 17,239. But, my lord, when you look at the decision of the Supreme Court, it's saying that, one, look at the margin. The leading candidate, what is the difference between what they have and what the runners-up have? And that margin, those are the two tests, my lord, my senior colleague took you through. And, my lord, I am going to highlight in the another decision, this decision of Hapenning. What did court say? And why are we having many other decisions departing from it?
So, Hapenning.
Yes, my lord.
Proceed.
My lord, it starts. It is not sufficient that there have been irregularities, but the petitioner must go further and show how they affected the results of the election. That's on page 679. It was left out, I don't know for what. It goes on, my lord. The court should look at the substance of the case and see whether the informalities or errors are of such a nature as to be firmly calculated in a rational mind to produce a substantial effect upon the election. But it goes on that the principle is that elections should not be lightly set aside simply because there have been informalities and errors. My lord, it goes to, when I go to page, I will make the point, my lord, after reading these excerpts. It's really important. On page 681, immediately after the highlighted part, paragraph 1, 2, 3, which the petition highlighted, there's another one. I find, like the trial court did, maybe, my lord, for context, let me read what the petitioner quoted. It was wrong to have added the number of the registered voters in the polling, in the 17 polling stations, to any of the candidates, because that was speculation as to who voted for whom, and it cannot be said that all of them voted for only the respondent, Hence, the trial judge had, when he added the total number of registered voters in the 17 polling station to the respondent alone. The following paragraph, my lord, says, I find, like the trial court did, that the non-compliance did not affect the results in a substantial manner. I don't know why my colleague left out that, but I can go on, my lord. Yes, ma'am. Yes, my lord. Yes, my lord. My lord, lastly, on paragraph, on page 683, paragraph, I think it's paragraph 3, it says that proof of the above fact, however, was, per se, not enough for the results of the election to be set aside. Section 61, subsection 1, paragraph A of the Parliamentary Election Act required the respondent to prove on the balance of probability to the satisfaction of court that the disenfranchisement affected the result in a substantial manner. It is significant to appreciate the fact that when the total number of registered voters of 8,844 from the 17 polling stations had been excluded from the total number of the votes cast, the first appellant remained with 41,165 votes, while the respondent had 33,486 votes. This means the exclusion of the results of the 17 polling stations, that the first appellant had a winning majority of 7,679 votes from the electorate of Tororo district. The winning majority would not likely grow higher if the results of the 17 polling stations were to be taken into account. It was not a fact that the exclusion of the results from the 17 polling stations affected all the candidates in the election equally, as none of them enjoyed any votes from any said station. So, my lord, the point I'm making is that this decision is of 2011 and 2011, and it was decided in 2012. That's when it was signed. But you have decisions of 2016, 2021 departing from this, and really the rationale are less distinguished, and also providing, the court then must provide what do they find faulty with the logic of the court used. My lord, we don't have it in many of the cases with the court report. But my lord, lastly, what was issue in the case of Kiza Messenger, and I will find a relevant page and highlight it, was in 206. My lord, I have the decision of 206, I'll highlight the necessary pages as well. The issue was considering what had been categorized as disenfranchised voters of 150 juxtaposed against 10 million. And that's what court was faced with. And Justice Katurebe followed the decision of the three justices that elections are about numbers. You cannot run away from that principle in the ballot box and also at the back. My lord, so my lord, with your permission, I can go and highlight the other cases that we used. Maybe when I finish, my colleague will highlight a mama power, because it's also important. So, my lord, then we would go to the case of Akukiziwe. Lawrence versus Muhumuza, David. My lord, that decision. Yeah. And my lord, why am I bringing this decision? Because something came in issue. What was it? We kept on being asked. I think in the submissions of the petitioner, it was that why were the counsel for the first respondent asking, why do you need another witness to prove this? Why do you need another witness to prove this? My Lord, again, why I brought the decision of Kizaresi, it is also part of this, in determining this issue. And the highlighted part, my Lord, is on page 17. Page 17. And my Lord, it addresses the issue of partisan witnesses. The issue of partisan witnesses. My Lord, it was also canvassed in Kizaresi, the decision of 2006. Why do you need to corroborate evidence of some witnesses?
So, my Lord, this is the reason why you need corroborated evidence of certain witnesses, because this is an election. It is a contest, highly contested. So, any person would first of all want to win at the ballot box.
If they have not been able to do that, they would want to overturn the win of the other in court. And my Lord, that's why the decision are saying, right from the Supreme Court, if you have a partisan witness who once says, I was an agent of, say, the petitioner, I saw the agent or a supposed agent of the respondent committing an illegal practice or an offense, there is no any other person, that evidence, my Lord, must be corroborated. Why? Because such a witness has vested interest in the victory of their one candidate in the election and now party in court. That is, my Lord, the decision of Hapenning, and it goes on with all the other decisions. My Lord, I think the same issue was canvassed in Salekamba. Yes, Salekamba, my Lord, on proving illegal practices. And my Lord, Kizibwe, also important on why do you need to cross-examine witnesses in election petition?
My Lord, you will find that necessary part. So, my Lord, the other decisions will be highlighted as my colleagues go on to canvassment of the other issues.
My Lord, just to supplement what my colleagues have said. Anakwea Musa, L-A-K-U-E-I-R-A, Musa, represent the first respondent, the first respondent. The petitioners introduced what I could term as a numerical margin test that to ascertain the substantiated effect of the result, you compare what number of the registered voters that was not included in the tally vis-a-vis the winning margin. In the Sarah Opendi case, Justice Remy Kasulo, in page 21, criticized this approach in his last page. He said, why court should not consider such an approach in evaluating the non-compliance and substantiated effect. This approach, these are its flaws. This approach overlooks the fact that each candidate at this election suffered equally from the decision of the Electoral Commission to exclude the votes from 17 stations from the final tally. That each candidate suffered equally is equal at that point. number 4, the respondent had to discharge the burden. In this case, is the petition. Had to discharge the burden that she would have got the majority of the votes if the votes from the 17th polling station had been taken into account, which she has not done. She didn't bring proof that any of those 17 polling stations she would have matched the winner. She even said in cross-examination she is assured of winning 2 polling stations where she voted from and where her fellow councillor, who is also an NRM candidate, voted from. That is Senator Masudi Lawrence. The judge said, the trial judge said, the approach what court should use is the one espoused in election petition number, Court of Appeal election petition number 17 of 2022, Edward Yaruhanga Katumba versus the Electoral Commission and another. That is on page 21 of Justice Rebecca, so criticizing the numerical margin effect. Going back to the Chiza-based case that was applied in the Tolik case, also cited by the petitioner, and Shuruk Mukesh Bubai versus Electoral Commission and another. This one was a 2021 election petition of this honorable court, where court emphasized what I'm interested in. Court says to look at the substantial effect, the court has to do an electoral audit. How does it do it? To assess the effect of non-compliance, the court has to evaluate, was quoting Kanokiza BCJ versus
the Ministry of Defense and Veteran Affairs as proposed in the bill should be adopted to enhance efficiency, transparency, and responsiveness in addressing pension-related issues for military personnel and veterans alike, welfare and health services. The committee observes the bill proposes establishing a health care service.
Using the tally sheet.
Madam Speaker, I'm rising on point of order. Earlier you had ruled that this front bench be reserved. As it is now, the several members appear to be part of my team, but when I invite them to support me, they shy away. Is it in order that they sit here when, is it in order for them to continue defying the ruling that you made, that this front seat be reserved for the members? Is it in order?
Honorable Wilson, continue.
Thank you. Right Honorable Speaker, I am now addressing committee's concerns and observations on welfare and health services. The committee observes that the bill proposes establishing a health care service for the Defense Forces personnel, creating a dedicated health care service for the military personnel,
listen to the
introduces
report.
Right Honorable Speaker, creating a dedicated health care service for the military personnel introduces extensive health care system, including routine medical care for the dependents of the officers and militants, rehabilitation services, and access to specialized treatments abroad when necessary. Additionally, a Defense Forces Medical Board has been established to manage medical evacuations, to manage medical evaluations, conduct disability assessments, and approve treatment for officers and militants. These reforms are designed to ensure that all military personnel receive timely, effective, and specialized health care during their service and after their service. The committee opines that a dedicated health care service for the defense personnel, separate from civilian addresses a unique nature of military service requiring specialized, timely, and continuous medical support tailored to risks faced by the defense forces. Military personnel often need rapid access to trauma care, rehabilitation for service-related injuries, and treatment for psychological conditions from combat or deployment. The Defense Forces Medical Board will ensure medical evaluations, disability assessments, and treatment decisions aligned with the military standards and readiness, which civilians' health care may not adequately address. The Joint Committee therefore recommends that 1. Establishment and operationalization of a dedicated healthcare service for the defense personnel, as opposed in the bill, be fully supported and adequately resourced to ensure the delivery of specialized, timely, mission-specific medical care, addressing the unique medical and psychological and rehabilitative needs of the military personnel. Monopoly and security classifications. The bill introduces measures to strengthen monopoly and security classification concerning crucial military assets of the UPDF. It specifically outlines which arms and ammunition are solely under the control of defense forces, guaranteeing that these materials remain inaccessible to unauthorized parties. Additionally, the identification and safeguarding of classified equipment and materials will now be regarded as sensitive to national security and will be strictly regulated according to military protocols. These reforms, Right Honorable Speaker and Honorable colleagues, aim to bolster national security, prevent unauthorized access, and uphold operational integrity by ensuring that only designated military officials oversee and protect these assets. However, the committee observes that the classification and the categorization of materials under the exclusive control of the defense forces, particularly military uniforms, can have significant implications for civilian wear. When clothing that closely resembles military colors, patterns, or designs are classified as military property, civilians wearing similar attire or clothing may face restrictions or even legal consequences. This is specifically in context where the resemblance is coincidental or fashion-based rather than intended to personate military personnel. For instance, in the bill under Clause 82, Schedule 7B, several uniforms for ceremonial wear, including ordinary black shoes, kaunda suits in the coffee brown, blue, and khaki, have been categorized as exclusive wear for the defense forces. Yet, these are very colors of clothing and black shoes are seen as ordinary wear by the public. Be that as it may, the committee asserts that civilians wearing military-style attire and berets, even without official insignia, significantly risks military identity, public trust, and operational scrutiny. Such apparel can confuse the public, undermine military distinctiveness, and grant an earned authority to those not following military codes. In operational or emergency situations, the difficulty in distinguishing trained service members from similarly attired civilians may compromise coordination and increase risks, potentially damaging the armed forces' professional image. Recommendations. We therefore recommend that Schedule 7B should be amended to include a requirement for marking military stores with the logos and insignia of the UPDF, thereby distinguishing them from civilian items. 2, that a provision should be inserted to restrict the wearing of camouflage military-style uniforms and berets by individuals who are not part of the military. Conclusion Right Honorable Speaker and honorable colleagues, we therefore recommend that the bill be considered for the second reading, subject to the proposed amendments attached hereto and any other modifications the House may propose and approve. Right Honorable Speaker and honorable colleagues, I beg to report.
Thank you so much. Thank you. As you informed that we have a minority report from Junior, Okot Moses Junior. Please present your report. Go to areas of dissent.
I'm not speaking.
Abib, you extend, you're disturbing Junior.
The Right Honorable Speaker and members, I move to present the minority report. But prior to the presentation, I intend to make an opening statement. In arriving at this report, we, the members of the joint committees of Defense and Parliamentary Legal Affairs, did in a higgledy-piggledy manner, haphazardly reached a position that would qualify the report that I am reading to be the majority report. And to justify the same, we had about 14 members signing this report out of the total number of members of these two committees.
How many members signed the majority report? Let's get a difference between majority and minority.
Right Honorable Speaker, the majority report has been signed by a total number of 26 members.
The joint, yes, then the joint 14 decide. Okay.
While I finish making my submission prior to reading to this report, is that I want to urge the members that if reason, persuasion, logic, and science has never taken the day in this House, let it take today, because this is a very critical part of the bill that I decided out of the opposition to remain in this House so that I present logic, science, reason, and law to the House.
Just finish and wait.
There's an order.
Thank you very much, Right Honorable Speaker. I rise on a point of order. This House is constituted of distinguished ladies and gentlemen representing this country, and we've been handling business since the beginning of this term. Is it in order for my friend to say we are illogical, that we have never applied logic in this House, and it is only him who is illogical in this House? When we represent our different constituencies, is in order to demean and insult us as members of this House?
Thank you. The members of this House reason with the reason and with the logic. And these are honorable members of Parliament. So whenever there is a debate here, it is done with the logic and reason. So we cannot have a House belittled to that level. So Junior, withdraw your statement. Junior.
Rightfully so, Right Honorable Speaker, I withdraw.
Honorable members, allow me to chair the House. Junior has withdrawn the statement and it will be expunged from the Hansard. Because the members that we have here are members of logic and reason, and they are honorable members of Parliament. Yes, Junior?
Right,
You
Honorable
go and
Speaker.
look for them.
Right, Honorable Speaker.
Junior, continue.
Right, Honorable Speaker, if the House may please, I will read.
Read your report.
Right, Honorable Speaker and colleagues, this is the statement of the minority members of the Joint Committee of Legal and Parliamentary Affairs, Committee of Defense and Internal Affairs on the decision of the majority in respect of Uganda People's Defense Force Amendment Bill 2025, herein referred as the UPDF Amendment Bill. This statement is made pursuant to Rules 214 and 215 of the Rules of Procedure of Parliament of Uganda. The UPDF Amendment Bill 2025 was read for the first time on Tuesday, 13th of May 2025, and in accordance with the Rules 134 and 200 referred Joint Committee of Parliamentary Legal Affairs and that of Defense for scrutiny. The object of the bill is to amend the Uganda People's Defense Force Act, Cap 330, to majorly give effect to the decision of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael Kabazaruka, among others. Pardon, members, I am born, raised, nurtured of a Luo descent, and there are certain syntaxes that may not appear.
Go ahead, Honorable Kabazaruka.
The decision of the Supreme Court in the Constitutional Appeal number 2 of 2021, Attorney General versus Michael Kabazaruka, is well detailed and uploaded. I am going straight to read the point of dissent to allow members probably. Point of dissent is on 330. And this is the substance of our submission. Our dissent from the majority is guided by Article 9, by the 1995 Constitution of the Republic of Uganda and the Supreme Court judgment in Attorney General versus Michael Kabazaruka, Constitutional Appeal number 2 of 2021, arising from Constitutional Petition number 45 of 2016. As a locus classicus case, in addition to other authorities, the point of dissent are: 1, contravention of the Constitution; 2, illegality in military trial; 3, offending the doctrine of separation of power; 4, lack of public participation; 5, unconstitutional expansion of the military court's jurisdiction; 6, constitutional limitation on Parliament's power; 7, lack of independence and impartiality of the court-martial; 8, non-compliance with the judicial advisory order of the Supreme Court ruling. Members and Right Honorable Speaker, on issues of contravention of the Constitution, Article 92 of the Constitution provides a restriction on retrospective legislation. Parliament shall not, if I may, Parliament shall not pass any law to alter the decision or judgment of any court between parties to a decision or judgment. The above provides a bar on legislative powers of Parliament in enacting any law that has effect of overturning or altering the decision or the judgment of court. Clause 30 of the bill proposes to introduce a new section, that is section 117A in the UPDF Act, to provide for other persons who are subject to military law. The provision requires that a person other than a member of the defense force shall be subject to military law under the following exceptional circumstances: where a person voluntarily accompanies any unit or element of the UPDF of the Defense Force which is in active service in any place. B, where while serving in Defense Force under the engagement by which he or she has agreed to be subject to military law. C, where the person is in unlawful possession of arms, ammunition, equipment, ordinarily being a monopoly of the Defense Force, prescribed in Schedule 7A of this Act, or classified as stores prescribed in Schedule 7B to this Act, commits an offense under any written law. D, where the person aids or abets a person subject to military law in the commission or conspires with a person subject to military law to commit the offenses. The offenses below: 1, murder; 2, aggravated robbery; 3, kidnap with intent to murder; treason, prison of treason, or cattle rustling. E, where the person without authority is found in possession of or sells or wears a uniform of the Defense Forces, or where the person is found in unlawful possession of arms, ammunition, or equipment ordinarily belonging to the monopoly of the Defense Force, prescribed in Schedule 7B of this Act. G, where a person is serving in position of an officer or a militant of any force raised and maintained outside Uganda and accompanied by the officer of the Defense Force. The above clause is an attempt to reenact Section 117 of the UPDF Act, which was struck down by the Supreme Court for offending Article 28(1), 44C, 128(1) of the Constitution. Such is inimical to the rule of law, good governance, which is a cornerstone of democratic dispersion, and that of other civilized nations and communities across the globe. It also constitutes an egregious attack on judicial independence, thereby contradicting Article 28(2) and 3 of the Constitution, which provides that no person or authority shall interfere with the courts or judicial officers in the exercise of judicial functions, and that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure effectiveness of the court. See Article 20 and 3. This action amounts of the Supreme Court is criminal, a path that must be leaded by Parliament. Honorable Speaker, Locus Classicus case.
Do you have to add a dissent, Parliament? Must you add dissent? Nobody doubts that we are dissent.
Avoided by our Parliament.
Expand the word dissent.
In the Locus Classicus case of Liang in 1967, there is Parliament a retrospective law affecting the trial of individual accused of attempted coup. Council struck down the law on account that it sought to alter the course of a particular decision and effectively overturn the jurisdiction. The Indian Supreme Court in Indira Nehru Gandhi versus Raja Nara in 1975 SC 2299, after election, was invalidated by the High Court constitutional amendment that was passed to validate the election. The Supreme Court struck the amendment, holding that the Parliament cannot enact legislation that overturns specific judicial decisions. Any legislation passed with the object of annulling the effect of a judicial decision has been held to be an encroachment on the judicial powers, and it is unconstitutional. Your Honor, coming down, there were other authorities that, Right Honorable Speaker, rather, and colleagues, there were other authorities that were cited year after to persuade the House. I urge members to peruse while I go to deal with the dissent. The second area of dissent is illegality in military trials. Your Honor, Speaker, the question of in military trial is ably canvassed by the Supreme Court in the case of Mike Kabaziruka in the above case. Owindolo CJ, in his lead judgment at 180 and to 180, this to Right Honorable Speaker. There are also other vital reasons militating against trials of persons to military law for all offenses. These courts has previously held that there are certain offenses that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to the specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on court-martial jurisdiction to try such offenses. For instance, since terrorism can only be tried by the High Court, which is an ordinarily civil court.
Honorable Court Junior.
Yes, Your Honor.
Honorable Justice, Chief Justice Owindolo had this to say. Open court, and then you close the court. Somebody will imagine
Most obliged.
that it continues up to the end.
Most obliged.
Close the
Right
court
Honorable
first.
Speaker. And if I may proceed from where I'd stopped, Right Honorable Speaker.
For clarity, say what Chief Justice said, open court, close it, then you bring your statement.
Right Honorable Speaker, the CJ, Justice Owindolo, in his lead judgment at page 180 to 185, had this to say. Open court. There are also other vital reasons militating against persons subject to military law for all offenses. This court has previously held that there are certain offenses that are not tried by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for cause by conferring court-martial jurisdiction to an offense. For instance, since it can only be by High Court, an ordinary or civil court would be contradictory to try it military court as well. And also it would be self-defeating for an offense similar to terrorism to be created under the UPDF Act, and then the persons are tried under it, close quote. I find this holding by Mulenga by Justice of the Supreme Court, Justice Mulenga, still position of the law, and where jurisdiction is expressly excluded, or where the DPP's consent is a prerequisite, the court martial are not competent to handle that matter, so excluded, irrespective of the provision to the contrary. Under the impugned section 117 and 117I, G, and H of the UPDF Act, it amounts to duplication to grant jurisdiction to the court-martial over it when, owing to the gravity of these offenses, Parliament conferred jurisdiction over them to ordinary courts. The other issue for consideration is the danger possessed by concurrent jurisdiction, where the military courts could try a case that is also before an ordinary court. This would necessitate the establishment of a mechanism between the court-martial and the DPP to manage the cases, beyond mere provisions in the UPDF Act, and the jurisdiction of the court-martial does not take away that of the civil courts. Concurrent trials in both military and ordinary courts for civil offenses would also be prejudicial to an accused, for a simple reason that it could lead to double jeopardy, as each court could potentially come up with a guilty verdict. Additionally, as already noted, the General Court-Martial and other military courts are subordinate courts. See, in the case of Attorney General versus Uganda Law Society, Constitutional Appeal number 1 of 2006. However, I do not agree with Justice Mulenga's finding, where I held that the General Court-Martial is subordinate but not lower than the Court-Martial. According to the Black Laws Dictionary, Brian A. Garner, 8th editions, subordinate means placed in or belonging to a lower rank or class or position, or subject to another authority or control. Assigning an ordinary meaning to the word subordinate, all court-martials as subordinate courts created under Article 129(1)D can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than that of the High Court is contradictory and has the potential to create an absurdity when it comes to hearing of capital offenses. If Parliament desires to grant them the jurisdiction to handle capital cases, then it would need to do so in line with the Constitution. I will return to this later in advisory opinion to explore the options that could be undertaken by Parliament to achieve this effect constitutionally. With this finding, the hearing by all court-martials of offenses within the jurisdiction of the court-martial is under 28, 128, 129D, close quote. The general rule alone have jurisdiction by civilians. The was able to any rational justification justify between the maintained dispute or maintain borders and civilians court generally. However, having held as above, the Chief Justice made the following orders. A, the provisions of 179(2) and now 171 and 2 of the UPDF Act.
171 or 177, 1 and 2.
179, 1, and then 1 and 2, and then 177, 1 and 2 of the UPDF Act. Read together with 197.2 and now 197.2, which grants subordinate military courts jurisdiction over capital offenses, contravenes Article 121D and 126 of the Constitution. And they are unconstitutional. Provisions of Section 1 and G. Now 1 and G is unconstitutional to the extent that it permits trial court martials of civilians who allegedly debated of offenses or criminal offenses in which a person subject to military law is a principal. Right Honorable Speaker, the minority observes, I'll jump D, the minority observes that the Supreme Court's decision had the following effects. The trial of civilians by court is only permissible in exceptional circumstances and only after state has concretely demonstrated to court by verifiable facts and by objective and serious reasons, need and justification for a recourse to a military court. 2, the minority observed that military courts can only have jurisdiction in relation to specific class, category of specific offenses. 3, for specialized courts such as Anti-Corruption Court under the Anti-Corruption Act, International Crimes Division under the Anti-Terrorism Act. 4, military courts cannot have jurisdiction of offenses which require the consent of the DPP. The consent of the DPP. 5, cannot commit or be tried for service offenses, even when abet or aid the commission of offenses. 6, when and military personnel are committed a crime, service offense, be tried in 7, Parliament cannot duplicate offenses prescribed by the acts of introduced in the UPDF. Colleagues, members of Parliament, the of appreciate the provisions of Article 28 to inevitable and incontrovertible conclusion that all persons, militant or otherwise facing criminal trials, to appear competent, independent, fair, impartial, or a tribunal. The decision of the Supreme Court, trial of persons with offenses
Man, ballet took forever. There's no railway here. Who took my compass?
And honourable members, I want to remind you, you've dated this report when you brought BFP ministerial statements, and I want you to be sensitive that we must handle this process and finish. I'm giving you